Good evening, friends. When we have Antraj Jha, a cyber law expert, the topics are niche, and therefore we requested her to again take a topic. What we talk of triple S, that is search, seizure, and summons, and digital investigation. The session, as usual, will be a combination of Hindi, English, and these sessions have been well received. And on behalf of Beyond Law CLC and Trikram and Associates, we welcome her and over to you, ma'am.
Thank you, sir. Thank you for the invitation, and I'm very thankful to you that you gave me this platform again, so that I can speak on this challenging topic, though it is important for the law enforcement. So let's start. Hello everyone, and thank you for joining me wherever you are watching from. So before we begin, just if we observe, we can look at our phone. That small object holds your entire life, your bank details, your late night conversations, your location history, your medical records, your photographs, and everything. So now the picture is the police at your door tomorrow asking you, hand it over, hand it your phone to the police person. So that single moment is where three ideas in criminal law collide with everything modern technology has built: search, seizure, and summons. The three words that sound almost bureaucratic on paper, and yet each one decides in the moment it's invoked whether a citizen's dignity survives an investigation. The gap between what technology allows and what the law permits, it exactly, I feel that where citizens get protected or get hurt to some extent, as we have seen that how nowadays this digital platform is being used and misused as well. So that gap is what we are here to explore here, not as a not as legal theory, but as something that could genuinely happen to any one of us, tomorrow morning before breakfast. So if we talk about this topic, so let's separate these three words: search, seizure, and summon, because although we use them almost interchangeably in daily speech, in law, they are distinct steps in one journey. If we talk about search procedure, so it is the act of looking. An officer acting under lawful authority enters a place, opens a device, or examines an account to some extent, we can say, to find something connected to an offense. A seizure is the act of taking once something relevant turns up, whether a laptop or a folder of emails. The officer takes custody of it, converting it from personal property into evidence. A summons is neither, it's a legal command asking someone to appear or to produce a document, record, or device without any kind of force being used at all. If we talk about the physical world, so these ideas are old and familiar. Search a house, seize a weapon, summon a witness. So judges have interpreted them for a century, but digital evidence breaks those comfortable boundaries in at least four ways. And I would like to keep these four things over here because we all return to them repeatedly. Now, the first volume says that a single smartphone today can hold more personal information than an entire filing cabinet did in the year 2000. Seizing a phone isn't seizing one letter, it's potentially seizing every letter a person has ever written or received. Second is the location. A photo on your phone might physically sit on a server in Virginia or Singapore, even though you look it in a Bhagalpur, a place in Bihar. Ask where the search actually happened. And the honest answer is often nowhere and everywhere at once. Now, if we talk about the third point, that is fragility. So, a knife stays a knife once seized. Digital evidence can change the instant you touch it. Simply switching on a phone can alter timestamps or override deleted data. That's why digital evidence demands a completely different discipline of handling, which we'll get to later. The fourth is the closest one, that digital evidence is intimate in a way a diary never was. Searching your house shows officers your furniture. Searching your phone shows them your fears, your health searches, your relationships, your politics, all indexed and searched and can be searched within a second. That's why courts everywhere, including our own Supreme Court, now treat a digital search as something we can say fundamentally different from a search of physical premises, deserving a higher order of constitutional protection. With that foundation laid, let's turn to where every conversation about Indian criminal procedure uh, has to start. Not a statute, but the Constitution itself. Now, if we talk about the constitutional foundation, so India's constitution never explicitly wrote in a right to privacy the way some other democracies did. For decades, that created real uncertainty about how far the state could go in searching a citizen's belongings, including eventually their digital belongings. So this uncertainty was settled in 2017 when a nine-judge bench of the Supreme Court in Justice K.S. Puttaswamy versus Union of India uh, unanimously held that privacy is intrinsic to the right to life and liberty under Article 21 of the Indian Constitution. This wasn't a small technical ruling, it was a philosophical angle. It told every investigative agency that a citizen's private sphere, digital included into it, cannot be entered except through a process that is fair, just, reasonable, and satisfies tests of legality, necessity, and proportionality. Now, the Article 21 works alongside Article 20, Clause 3, our constitutional shield against self incrimination, the right not to be compelled to be a witness against yourself. Historically, this covered things like forced confessions. In the digital age, it has taken on strange new life because unlocking a phone often means revealing a password, PIN, or biometric. Is that closer to handing over a physical key, which courts have always allowed, or closer to compelled testimony from inside someone's own mind, which the Constitution forbids? This tension was tested memorably in Selvi versus State of Karnataka 2010, which dealt with narco analysis, brain mapping, and polygraph tests. The court held that subjecting someone to these techniques without free Informed consent violates both the right against self incrimination and personal liberty. That reasoning behind it was that person's own mind cannot be forced open by the state. It is the intellectual ancestor of every later debate about forcing someone to type in their phone's password. So, whenever we talk about search, seizure, and summons of digital evidence in India, uh, we are really describing a constant balancing act between two legitimate values: the state's genuine need to investigate that particular crime, and the citizens' equally genuine right to privacy and silence. Neither is allowed to swallow the other. Keep that balance in mind. Every statute and case we discuss here is really just another attempt to draw that same line in a slightly different place. So, when we talk about its statutory architecture, so for 70 years, criminal procedure in India lived inside the Code of Criminal Procedure, 1973. And on 1st July 2024, it was replaced by the BNS, Bharatiya Nagrik Suraksha Sanhita, the first Indian procedural code which built with digital evidence in mind from the start, rather than bolted on awkwardly as had been happening under the CRPC for 2 decades. Three provisions of the BNSS matter enormously here. The first section, that is 94, on summoning documents and things. Earlier courts had to stretch the definition of document to cover emails or call records. The BNSS closes that gap directly. A court or officer can now expressly demand production on any document, electronic communication, or the device itself, we can say, where it's likely to contain relevant evidence. Refusal without lawful excuse is itself a punishable offense under the corresponding provision of Bharatiya Nyaya Sanhita. That's the summons of a title finally given digital teeth. Second, if we talk about the search provisions, largely carry forward familiar structures, uh, uh, like warrants, urgent warrantless searches, independent witnesses, proper inventories. What genuinely new? And I think one of the most important reforms in the whole code is Section 105, which makes it mandatory to record the entire search and seizure process on audio or video with a mobile phone, specifically named as the preferred tool, forwarded without delay to a magistrate. Think about what that means. For decades, search disputes came down to one person's word against another's. A mandatory video record won't end every dispute, but it dramatically raises the cost of misconduct on either side. Third, seizure itself is restructured because the power to seize is now separate from the procedure that follows. How seized property, digital devices included, must be listed, safeguarded, and eventually returned, produced, or disposed of. Splitting these forces the state to treat taking and accounting for what was taken as two distinct duties each independently testable in the concerned court. Running alongside, the BNSS is the Information Technology Act 2000, still the backbone of substantive cyber law. Its most relevant provision here is Section 69, which lets the government direct interception, monitoring or deception or decryption of information on specific grounds, sovereignty, security, public order, and so on. Deliberately hedged with safeguards, because unrestricted interception power would make a mockery of the Article 21 protection we just discussed. Finally, no discussion of digital evidence is complete without the law of evidence itself. So the old Indian Evidence Act 1872 has been replaced by the Bharatiya Sakshi Adhiniyam. What used to be the famous is Section 65B on admissibility of electronic records, now lives on through sections 61 and 63. The core idea survives intact. An electronic record, a WhatsApp chat, a CCTV clip, a server log can't simply be handed to a judge and accepted at face value. It generally needs a certificate confirming how the producing device was functioning. So the court can trust the evidence hasn't been altered, or we can say fabricated. We'll spend some real time on this issues. Like certificate requirement shortly is required because it has produced one of the most fought over lines of judgments in Indian evidence law. So in the plain language, we can say that the BNSS tells police how to go with the search, seize, and summon process. The IT Act governs the special power to intercept or decrypt, and the Bharatiya Sakshi Adhiniyam decides whether what was collected can actually convict or acquit someone. 3 statutes, 3 jobs, 1 continuous chain of custody from seizure to judgment. Now, one more statute deserves a mention before we move to the courtroom, because it sits in genuine unresolved tension with everything discussed so far. The Digital Personal Data Protection Act is India's first comprehensive data protection law built on consent, purpose, limitation, and individual rights over one's own information. Yet Section 17 carves out a significant exemption. Several of the Act's core obligations don't apply where data is processed for preventing, detecting, investigating, or prosecuting an offense. And the government can, by notification, exempt any agency from the Act altogether on grounds like sovereignty and security. I raise this honestly rather than glossing over it. Supporters say it's necessary a data law that let a criminal suspect invoke privacy. To block a lawful investigation would defeat the purpose of criminal justice. Critics, including constitutional scholars, argue that an exemption granted through a simple notification without a built-in case-by-case judicial test sits uneasily with the proportionality standard the Supreme Court itself let down in Puttaswamy case, a standard it had already applied years earlier in PUCL versus Union of India on telephone surveillance. So both sides deserve to be heard, and I genuinely expect this exemption to be tested in court in the coming years, a direct sequel to everything where we are about to discuss. Now, statutes tell us what the law says. Cases tell us what it actually does when real people with real stakes stand before a judge. So let me walk you through the cases that have shaped digital search, seizure, and summons in India. Each one a genuine human drama. Some of these cases we may have half remembered or from a news headlines years ago. In November 2004, an IIT Kharagpur student listed an obscene video clip for sale on Bazi.com, India's leading auction platform, later acquired by eBay. I think we all are aware of this platform, eBay. The listing came down within roughly 38 hours, but the Delhi police had already registered a case and remarkably arrested not just the seller, but Avnish Bajaj, the platform's owner, CEO, along with a senior employee, charging them under obscenity provisions and Section 67 of the IT Act. When Bajaj sought bail in Avnish Bajaj versus State, Justice Vikramjit Singh granted it while distinguishing a platform what merely hosts a listing from one that actively publishes obscene content. Bajaj was eventually cleared of personal criminal liability. And I mentioned this not as a search and seizure case in the narrow case, but in a narrow sense, but because the alarm it caused that any executive could be personally arrested for content posted by an anonymous user directly pushed Parliament to strengthen the safe harbor protection for intermediaries under Section 79. Early investigations, including who gets summoned and arrested, don't just decide one case, they can reshape an entire industry's relationship with the law for decades. The other case which I want to discuss is Anwar PV versus PK Bashir. In this, an election dispute with enormous criminal law impact, the court held that Section 65A and Section 65B of the Old Evidence Act form a complete self-contained code for electronic evidence. Without the certificate, such evidence simply can't be treated as proof. This was the moment Indian law drew a hard line. Digital evidence needs its own special proof of authenticity. Now, the 4 years later, Shafi Muhammad versus State of Himachal Pradesh softened this. Holding the certificate requirement could be relaxed when the device wasn't in the possession of the party relying on it. For a while, courts were genuinely split between the strict and the flexible approach. That confusion was resolved in 2020 in Arjun Panditrao Khotkar versus Kailash Kushanrao Gorantayar. A case born almost from a Maharashtra Assembly election won by under 300 votes. where video footage was used to allege nomination papers were filed late, a larger bench restored the strict position. The certificate is mandatory for secondary electronic evidence, and Shafi Muhammad's relaxation was wrong. But the court showed real practical wisdom too, where the original electronic record itself is produced, not a copy. The certificate requirement doesn't apply the same way, and courts can compel the certificate from the relevant person if a genuine party can't obtain it alone. I find this case very fascinating precisely because something as unglamorous as a certificate, a piece of paper, confirming that how a machine was working has become the single most litigated safeguard in Indian digital evidence law. It's the law's way of saying machines can be trusted only when a human takes formal, accountable responsibility for them. From admissibility to something more personal, unlocking your own phone in the case Virendra Khanna versus State of Karnataka. The petitioner, an accused in a high profile narcotics case connected to the film industry, was directed to unlock his phone and email accounts and refused, prompting a proposed polygraph test. He argued that being forced to reveal a password is a violation of privacy under Puttaswamy and self-incrimination under Selvi case. The Karnataka High Court held that providing a password or biometric is closer to producing a physical key than to giving testimony. So it doesn't by itself violate either protection, provided the process is lawful, and it laid down detailed guidelines for how such unlocking should happen. And I want to be honest that Virendra Khanna isn't the last word. Commentators and later litigants, including in matters before the Delhi courts, they pointed out that this reasoning may sit uneasily with Selvi case since a password, unlike a fingerprint, comes purely from memory, and forcing its disclosure arguably does compel revealing the contents of one's own mind. So, whether a compelled phone password is testimonial and protected or non testimonial and compellable remains genuinely unsettled. And I suspect the Supreme Court will finally resolve it in the coming years. When it does, it will be among the most consequential digital rights judgments this country has produced. Now, a case showing the human cost of getting procedure wrong, recent, still fresh in memory. If we talk about in October 2023, Delhi police searched more than 30 locations connected to the news portal NewsClick under the Unlawful Activities Prevention Act, seizing devices belonging to numerous journalists and arresting the portal's founder. I'm not commenting on the underlying political controversy. That's not the point of discussion. But what matters is, in May 2024, in Prabir Purkayast versus State of NCT of Delhi, the Supreme Court quashed the arrest and remand entirely because the grounds of arrest had not been communicated to the accused in writing before remand. So, violating the rights, that failure alone was enough to invalidate everything that followed. The lesson to remember long after this that even a procedurally thorough looking operation with warrants and properly seized devices can collapse if a basic constitutional safeguard like informing someone is right in writing now that in writing why they are being arrested. Technology may be new. The constitution insistence on basic fairness is not negotiable. One more thread worth weaving in, since so many of you are aware of this case, I think, in Karmanya Singh Sareen versus Union of India, the Delhi High Court and later the Supreme Court on appeal examined WhatsApp's 2016 privacy policy update proposing to share user data with its parent company. Though the case ultimately turned on contractual and regulatory questions rather than criminal search and seizure, it spotlighted a question every digital investigator now faces. When your chat data sits on a platform servers rather than your own device, who really controls? Who can lawfully demand it? And under what safeguards? That question echoes directly into every summons on an Indian agency now sends a tech company for chat records or metadata. Before we cross into international law, a quick note for those that asking in the chat whether ordinary citizens, not accused persons, have any right if police ask to see their phone at a routine checkpoint. Honestly, outside a lawful warrant, a valid summons, or a specific statutory power, no officer has an unrestricted right to browse your phone. You are entitled to ask under what legal provision the search is happening and to have it properly recorded. Knowing your rights isn't obstruction, it's participation in the rule of law. One more case before we move to forensics, because it's the clearest lesson in Indian law, which has given us about what happens when a digital too loosely. That case was Shreya Singhal versus Union of India. The case grew out of Section 66A of the IT Act, which criminalized sending grossly offensive or uh, menacing information or anything causing annoyance or inconvenience. The trigger was painfully ordinary. In 2012, two young women in Mumbai were arrested for a Facebook comment questioning a citywide shutdown after a political leader's death. That arrest and the outrage that followed revealed how a vaguely worded offense could hand police almost unlimited discretion to search, seize, and arrest for nothing more than an opinion. The Supreme Court struck down Section 66A entirely, holding its language unconstitutionally vague and chilling to free speech under Article 19. But, and this nuance matters, it didn't strike down everything connected to online content. It upheld Section 69A on government blocking of content and read down Section 79 safe harbor, clarifying that platforms need only remove content once properly directed by a court or lawful government order, not on the basis of vague private complaints. The court drew exactly the kind of line we discussed earlier, protecting the state's legitimate power while refusing to let sloppy drafting become a tool for arbitrary search, seizure, and arrest. I include this case as a bridge because it reminds use of something no forensic expert can ever fix. No hash value, no write blocker, no certificate of authenticity can correct a law that was badly drafted in the first place. Integrity of digital investigation begins not in a forensic labs, but in the wording of the statute that first authorizes the search. The first principle of digital forensics taught in every serious lab that never examine the original evidence directly if you can help it. Switching on a seized phone and clicking around risks changing timestamps, triggering updates, or overwriting recoverable deleted material. So investigators create a forensic image, a perfect bit for bit copy of the entire storage device. Deleted fragments and hidden areas included captured without altering the original. This typically uses a write blocker, a hardware device that allows reading but blocks any writing back. All analysis happens on the copy. The original stays sealed, ready to be produced if its integrity is ever challenged. Now, how do we know the copy examined months later truly matches what was seized on day one? So, through a hash value. Algorithms like MD5 or the stronger SHA 256, essentially a unique digital fingerprint calculated from every bit of data. Change one character anywhere, and the hash changes completely and unpredictably. Investigators hash that image moment it's created, and again at every later examination. If the values match exactly, judge, prosecution, and defense alike can be confident nothing has been tampered with. This single piece of applied mathematics is honestly one of the quietest but most important safeguards in digital investigation. It replaces human trust with mathematical certainty. Alongside hashing sits the chain of custody. Now, every person who touches the evidence, from the seizing officer to the analyst, logged with date, time, and purpose, any unexplained gap becomes fertile ground for a defense lawyer to argue tampering, and Indian courts take these arguments seriously. Now, let me flag two of the technical challenges today. The first is encryption. Modern phones and messaging gaps increasingly encrypt by default so strongly that even the company that built them often can't read the content without the user's own key. This is the going dark problem. Investigators holding a perfectly valid warrant, technically unable to access the uh, uh, very evidence it permits. This is exactly the tension behind the 2016 standoff between Apple and the FBI after the San Bernardino shooting, where when the FBI sought a court order compelling Apple to build software disabling the phone security so investigators could guess the passcode. Apple refused, arguing that even a single use tool would create dangerous permanent vulnerability. The case never got a final ruling. The FBI found a third-party method and withdrew, but the underlying question whether a court can force a company to weaken its own security architecture remains one of the most actively debated in technology law worldwide. Three more technical layers is required, like briefly, because each shows up constantly in real investigation. Volatile memory is one of them, that is RAM, which disappears the instant power is cut, yet can hold passwords and encryption keys. So, skilled teams sometimes perform a live acquisition, capturing it before a device is ever powered down. Metadata, it is a data about data, which is never deleted, which can't be deleted. Means a photograph isn't just an image, hidden EXIF data that often records the exact device time and even GPS coordinates. This quiet layer has cracked open more investigations than people realize. Because criminals careful about what they say are often careless about what their devices silently record. And cryptocurrency and blockchain tracing matters increasingly since digital financial crime often moves through wallets rather than bank accounts. Investigators now use specialized tools to follow the public permanent trial. Most crypto transaction leaves tracing funds across, we can say, wallets and exchanges, even when the people behind them believe themselves anonymous. The second big challenge is cloud forensics. So much of our digital life lives on remote servers, often in another country entirely. Investigators generally can't seize a physical box. They must send a formal legal request to a company that may be governed by an entirely different country's laws about if and how it responds. That single fact that our data lives beyond our national borders is the bridge that carries us from Indian domestic law into international cyber law, which is where I want to take you next. Now the crime has always occasionally crossed borders, but cybercrime crosses them by default. There is no boundary. A fraud call center in one country can defraud a victim in another, using a server in a third, laundering money through fourth. So no single police force can investigate that chain alone. That reality has slowly forced the international community to build frameworks for cross-border cooperation. The oldest and still most influential is the Budapest Convention on Cybercrime, the world's first treaty dedicated to harmonizing cybercrime laws and enabling cooperation, including a round the clock network of contact points for urgent evidence preservation. More than 80 countries have joined through India never has largely over sovereignty concerns and a provision allowing certain cross-border data access without first going through the requested state's government. Because India and the other major nations, including Russia and China, stayed outside Budapest, momentum built toward a genuinely universal UN treaty. After roughly 5 years of negotiation, the United Nations Convention Against Cybercrime was adopted by the UN General Assembly on 24th December 2024 and opened for a signature in Hanoi in October 2025. Hence its informal name, the Hanoi Convention, remaining open until end of 2026. This is the first comprehensive global criminal justice treaty negotiated at the UN in over 2 decades, designed to speed up and standardize across border uh, evidence sharing for serious offense like online child signed reportedly over continuing concerns about privacy safeguards. and data sovereignty, a live, evolving story worth watching. Another option is the Mutual Legal Assistance Treaty, MLAT. This mechanism is being used by the Indian investigators when agencies need evidence held abroad, say email data on a US server. A formal request travels through diplomatic and judicial channels, typically via India's Ministry of Home Affairs. We can have a look. We can see its format. It is available on the MHA official website, and Ministry of External Affairs to the country's central authority. These requests are legally sound, but notoriously slow, sometimes taking months or years. Exactly the kind of delay that can be fatal when evidence risks being deleted long before a request is even answered. That slowness is what the United States tried to fix through domestic legislation in a case that changed the global conversation about cross-border evidence. United States versus Microsoft Corporation. So the Microsoft Ireland case, in December 2013, US investigators sought an email account's contents under a warrant tied to a narcotics case. Microsoft complied for domestic data but refused for content stored on a server in Dublin, arguing an American warrant had no reach over foreign soil. The dispute climbed to the US Supreme Court with oral arguments in February 2018, and the justices themselves wondered whether this was really a matter for courts or for Congress. Congress answered almost immediately. In March 2018, it passed the Cloud Act, clarifying that a US-based provider must produce data within its control regardless of where it's physically stored. The government obtained a fresh warrant under the new law, and the Supreme Court declared the original case moot. The Cloud Act also lets the US strike executive agreements with trusted foreign governments, letting their agencies request data more directly, bypassing the slow MLAT process, provided that countries' laws meet certain privacy standards. One more regional development worth a mention. That is the EU's General Data Protection Regulation 2018 is chiefly a privacy law, but it genuinely affects cross-border investigation too, since it restricts transferring EU citizens' personal data to countries whose protection it doesn't consider adequate. That's exactly the issue behind Schrems second, which struck down the transatlantic data transfer arrangement between the EU and US, holding American surveillance law didn't offer Europeans sufficiently equivalent protection. So for investigators anywhere, including India, seeking data tied to a European citizen or server, this adds another careful layer to navigate alongside whichever treaty or MLAT might otherwise apply. The EU has, in parallel, been building its own internal e-evidence framework, letting law enforcement in one member state request evidence more swiftly from a provider in another its own regional answer to the same delay problem the Cloud Act addresses for America, and that the new UN convention hopes to eventually solve globally. Finally, No discussion of international cooperation is complete without Interpol, which operates a genuinely useful, often misunderstood system of international notices and a secure communications network letting member countries, India included through the CBI, share intelligence and coordinate against transnational fraud networks and dark web marketplaces. It wasn't a world police force with its own search and seizure powers. A common misconception was that it's a coordination hub that member states rely on constantly. Now, before returning to the international stage, one final time, let me show the pointer machinery that makes an Indian digital summons actually work. Because none of the uh, uh, without discussion, without discussing the I4C, that is Indian Cyber Coordination Center, I think it is also important to discuss this, that this organization was set up under the Ministry of Home Affairs, gives India's fragmented state by state police machinery a single coordinated backbone, including the National Cybercrime Reporting Portal and the widely known, that is 1930 helpline. When you report financial cyber fraud today, it increasingly triggers an automated, time sensitive freeze request to banks and payment platforms. Because in digital fraud, speed of seizing funds matters much as eventually seizing a suspect's device. Secondly, is certain under the IT Act issued sweeping directions requiring internet service providers, cloud providers, and VPN providers to retain system logs for a rolling 180 days, and the VPN hosting providers to retain detailed subscriber information for up to 5 years, all stored within Indian jurisdiction. Now, the purpose is that giving investigators a reliable trial of digital breadcrumbs, since crimes are so often discovered weeks or months after they occur. But the directions drew real criticism from privacy researchers and industry, who argued that blanket retention for every user, regardless of any connection to crime, sits uneasily with the data minimization principle that India's own developing privacy jurisprudence, following Puttaswamy, is meant to protect. Several well-known international VPN providers, unwilling to comply, simply withdrew their physical servers from India rather than build the required logging infrastructure. I share this not to tell who's right, but because it's perfect live illustration of the exact tension we have circled all. The state's genuine need for a workplace evidentiary trial against a citizen's equally genuine right to move through the digital world without every click being permanently recorded. Now, everything is discussed so far. Again, I want to discuss the Pegasus spyware controversy, and it belongs here precisely because it shows that what digital intrusion looks like when it escapes the search and seizure framework entirely. In July 2021, an international media consortium and Amnesty International reporting as the Pegasus Project revealed that a list of phone numbers, reportedly including Indian journalists, activists, and public figures, may have been selected as potential targets of Pegasus, spyware developed by Israel's NSO group, capable of infiltrating a phone via a zero-click vulnerability requiring no action from the owner at all. Then silently harvesting messages, calls, photos, even live microphone and camera access. Multiple petitions reached the Supreme Court, and in October 2021, in Manohar Lal Sharma versus Union of India, the court constituted an independent technical committee overseen by a retired judge because the government repeatedly invoked national security to avoid filing a detailed affidavit. The court made a point worth remembering. Even a lawful encroachment on privacy must satisfy proportionality, and national security cannot be a blanket shield against judicial scrutiny. The committee examined a number of devices, confirmed some form of malware on a handful, though it couldn't conclusively confirm Pegasus specifically, and noted it hadn't received full government cooperation. Now, I share this case honestly because it is the necessary mirror image of everything else. Search, seizure, and summons, however imperfectly implemented, at least operate inside a visible legal architecture. A citizen can eventually question before a court, exactly as in the case of Virendra Khanna did, exactly as Prabir Purakayas did. Now, covert spyware intrusion by design denies a citizen even the chance to know it happened, let alone challenge it. That asymmetry between a state that must justify itself when it knocks and one that never has to explain itself if it never knocks at all is perhaps, I feel that the single biggest reason for, say, for tonight's safeguards are worth defending it, not dismissing as paperwork. Now, we discuss all these things that we discuss the Constitution through the BNSs and the IT Act through courtrooms. Now, we have traveled tonight from a knock on a door in an Indian city through the Constitution, through the BNSs and the IT Act, through courtrooms in Bangalore, Delhi, and Nagpur, all the way to Hanoi, signing ceremonies and a courtroom battle in California over one logged iPhone. Let me bring it back to something simple and human. Now, every safeguard we discussed, mandatory video recording of searches, hash values that mathematically guarantee evidence hasn't been altered, certificate requirements, the constitutional insistence on written grounds of arrest, treaty negotiations happening right now in rooms most of us will never see, exist for one purpose: to make sure the extraordinary power we give the state to search, seize, and summon. A power we give willingly because we want criminals caught and victims protected. That is the more important part. Never quietly becomes a power used to intimidate or harm an innocent citizen without real accountability. I don't believe either extreme serves as well. A society where police can't effectively access digital evidence becomes a paradise for fraudsters and traffickers. But a society where digital search and seizure happens without meaningful judicial oversight, without documentation, without respect for what a smartphone actually contains, becomes one where privacy exists only on paper. The whole quiet, unglamorous architecture we discussed tonight lives, we can say that precisely in that narrow space between the two extremes. Virendra Khanna case shows the law still working out its own contradictions. News click shows even careful looking procedure can collapse without constitutional discipline. But the direction of travel from a silent CRPC to a BNSS that mandates video evidence of every search, from an evidence law that once ignored electronic record to one built around them tells something genuinely hopeful about where Indian cyber law is heading. If there is one image I want you to carry out of it, this room, that it's the one we opened with your phone sitting on the table in front of you, holding more of your life than any cabinet drawer or diary ever could. Every rule we discussed here is really just society's attempt to decide carefully and imperfectly when someone else is allowed to reach for that phone and what they owe you in return for doing so. So, thank you from my side. Open for a question.
I'm just checking out. One is saying, can you share the list of cases? So that you can always share it to me. We will post it on the website.
I'll do that. I'll do that.
Just मैम तब तक आप थोड़ा हिंदी में समझा दें क्योंकि आज थोड़ा इंग्लिश पे ज्यादा जोर रहा है।
हाँ हाँ बिल्कुल सर। मैंने जितनी भी चीजें समझाई हैं ये मैंने समझाने की कोशिश की है कि जब भी हम डिजिटल एविडेंस एक्सट्रैक्ट करते हैं, जनरली तो ये आयोग का इसमें रोल काफी ज्यादा इंपॉर्टेंट होता है और जो एफएसएल के एक्सपर्ट हैं उनकी भी रोल काफी ज्यादा इंपॉर्टेंट है। तो जब भी हम एक्सट्रैक्शन पार्ट करते हैं तो उसकी एक कॉपी बना लें, यानी ओरिजिनल एविडेंस में से हमें एक्सट्रैक्शन नहीं करना, क्योंकि अगर वो डैमेज हो जाएगा तो फिर बड़ी मुश्किल होगी फिर से एक्सट्रैक्शन करना। और ये भी मुश्किल होती है, कभी कभी ऐसा भी केस मैंने एक बात देखा है जिसमें क्या होता है ना, एविडेंस का जो जो आपका जो सिस्टम है, जो फोन है या जो भी गैजेट है जिसमें से एविडेंस एक्सट्रैक्ट होना है, वो इतने डैमेज फॉर्म में होते हैं कि उसमें से फिर से निकालना वो डिफिकल्ट होता है। तो इस वजह से हैश वैल्यू भी चेंज नहीं होना, ये भी हमें ध्यान रखना है। तो ये चीजें जो है हमें कुछ बेसिक हैं जो हमें समझना है। हालांकि ये काफी ज्यादा जो ये डिजिटल एविडेंस, डिजिटल फॉरेंसिक थोड़ा सा चैलेंजिंग भी है, क्योंकि एक्सट्रैक्शन सही तरीके से हो, एक्सपर्ट हो सही जो उसका एक्सट्रैक्शन सही तरीके से कर सके। तो ये चीजें हमें, और कुछ केसेस जो हमने बताए हैं जो काफी लीडिंग केसेस थे, वो भी मुझे लगता है कि बताना सही था, तो मैंने डिस्कस किया। और इंटरनेशनल प्लेटफॉर्म पे जो चीजें हम डिस्कस करते हैं, जैसे अगर हमारी ट्रीटी अगर साइन है, जैसे हम एमलाट के थ्रू जाते, जो हमने डिस्कस किया म्यूचुअल लीगल असिस्टेंस ट्रीटी के बारे में हमने डिस्कस किया, तो उस प्रोसीजर के थ्रू हम जाते हैं, है ना। अगर मैं बोलूं, क्योंकि आई वर्कड ऑन इट, सो इट टेक 1.5 to 2 years अगर प्रोसीजर से हम जा रहे हैं। और उसमें भी कभी कभी ऐसा होता है ना कि ये तो प्रोसीजर से हम जा रहे हैं, लेकिन किसी एक मिस्टेक की वजह से, अब जैसे स्पेलिंग मिस्टेक हो गया या पेज नंबर सही तरीके से नहीं लिखा है, तो इसकी वजह से वो वापस कर देते, फिर से वो उतना टाइम लगना है ना। तो ये काफी लेंदी प्रोसेस हो जाता है। तो इस वजह से हमें, अगर ये तो पहले पता होना चाहिए, अगर इंटरनेशनल प्लेटफॉर्म पे ऐसे कुछ क्राइम हुए हैं तो उन तक हम कैसे पहुंच सकते हैं, क्या हमारी ट्रीटी उस कंट्री के साथ साइन है। तो ये सारी चीजें ही हमने डिस्कस करने की कोशिश की है।
मैम फ्यू क्वेश्चंस आपके लिए, मतलब वैसे आम आदमी के लिए, व्हाट इज द लीगल डिस्टिंक्शन बिटवीन सर्च, सीजर एंड समन डिजिटल इन्वेस्टिगेशन?
लीगल रिस्ट्रिक्शन, देखिए सर्च सीजर प्रोसेस में जितनी भी मैंने बातें बताई हैं, लीगल रिस्ट्रिक्शन की बात अगर मैं, जी
लीगल डिस्टिंक्शन मैम, लीगल डिस्टिंक्शन इन तीनों चीजों में।
हाँ, लीगल डिस्टिंक्शन है कि प्रोसीजर कैसे कौन कैसे कर सकता है। अच्छा, इसमें एक चीज और भी हमें समझना है, प्राइमरी या सेकेंडरी एविडेंस जो है उन चीजों को भी हमें समझना है, किसे हम सेकेंडरी एविडेंस में हम डाल सकते हैं, किन्हें हम प्राइमरी एविडेंस में डाल सकते हैं। एक एग्जांपल के थ्रू भी मैं ये भी आपको समझाना चाहूँ, जैसे प्राइमरी एविडेंस में अगर चीजें डायरेक्ट आपके मेल पे है तो आपने उसे तो प्राइमरी एविडेंस में कंसिडर कर लिया, लेकिन यही चीज अगर आपकी पेन ड्राइव में आपने ट्रांसफर कर दिया है ना, या फिर सीडी में ट्रांसफर कर दिया, तो ये आपका फिर सेकेंडरी एविडेंस में चला जाएगा। अब सेकेंडरी एविडेंस जैसे ही हमने डाला तो कोशिश ये होगी कि वहां पर हमें सर्टिफिकेट अटैच करना पड़ेगा, जो पहले 65B था एविडेंस एक्ट का, अब सेक्शन 63 हो गया साक्ष्य अधिनियम का, ना। तो
नेक्स्ट है, is a search warrant mandatory before a digital device can be searched or seized?
यस,
Can can a person be compelled to disclose the password, PIN, or biometric lock?
क्या क्या है क्वेश्चन?
मैम क्या किसी को कंपेल कर सकते हैं वो अपने पिन एंड बायोमेट्रिक्स देने के
कंपेल
लिए?
नहीं,
कैसे?
नहीं, वी कांट कंपेल, वी नीड टू आस्क देम, वी नीड टू आस्क देम, पूछ करके, क्योंकि फिर वहां पे प्रिवेसी वाला इशू जो मैंने अभी डिस्कस किया वो रेज होगा। लेकिन कुछ केसेस जो मैंने वो फिर मैं शेयर भी आप लोगों से कर दूंगी, लेकिन वी कांट कंपेल बिकॉज अगेन दे कैन से दैट देयर राइट ऑफ प्रिवेसी इज बीइंग डैमेज्ड।
थैंक यू मैम, बहुत बहुत शुक्रिया आपका। विक्रम एंड एसोसिएट्स एंड बियॉन्ड लॉ की तरफ से आपसे
थैंक यू,
दोबारा मुलाकात होगी।
थैंक यू सर।
थैंक यू।